Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Hakeem Green. Decided May 28, 2026. Canataro, J. The issue presented by this appeal is whether strong and extensive family support and gainful employment can serve as mitigating circumstances not adequately taken into account by the Sex Offender Registration Act's Risk Assessment Guidelines. Sex Offender Registration Act, Risk Assessment Guidelines, and Commentary, Guidelines, 2016, for purposes of a request for a downward departure from a presumptive risk level. We hold that they can, but that in this case, the Appellate Division did not abuse its discretion in determining that defendant failed to meet his burden of establishing the existence of these mitigating circumstances by a preponderance of the evidence. Between October and December 2012, defendant held two young women against their will and forced them to engage in prostitution. During this period, defendant also raped both women and committed numerous additional acts of violence against them. In May 2013, defendant was convicted upon his guilty plea of 2 counts of sex trafficking, Penal Law Section 230.345, and was sentenced to 6 to 12 years imprisonment. In 2019, in anticipation of his release from prison, the Board of Examiners of Sex Offenders, BOARD, prepared a risk assessment instrument, RAI, that assessed defendant with a total of 130 points, qualifying him as a presumptive Level 3 sex offender and finding no basis for a downward departure. Notably, defendant was assessed 0 points for his release environment, including under Risk Factor 15 for his living/employment situation. Following his risk assessment hearing, Supreme Court scored defendant with 115 points, resulting in a presumptive Level 3 sex offender designation, and denied his request for a downward departure. The Appellate Division reversed and remitted for a new hearing to allow Supreme Court to consider 2 issues, including defendant's request for a downward departure. Prior to the hearing on remittal, the people submitted an RAI assessing defendant with 115 points, which still classified him as a presumptive Level 3 offender. In support of his downward departure request, defendant emphasized that he had been living offense-free in the community for the 3.5 years since his release from incarceration, and argued that there were mitigating factors not adequately accounted for by the guidelines, including, as relevant here, his gainful full-time employment and strong family support. He explained that he had worked as a food delivery driver, obtained his commercial driver's license, become a full-time truck driver, and eventually purchased his own tractor-trailer and founded a freight trucking business. Additionally, defendant supplemented his income by working nights and weekends parking cars as a production assistant on film sets. He viewed his recent history of full-time employment as a significant contributor to a reduced risk of reoffense, characterizing his past crimes as being financially motivated. In further support of this proposed mitigating factor, defendant cited to statistics documenting the difficulties faced by many formerly incarcerated people, especially sex offenders, in obtaining employment, as well as a publication concerning the importance of structured full-time employment in preventing recidivism. To establish his alleged strong family support network, defendant referenced his committed relationship with the mother of his young child and submitted brief letters from 4 family members and a former landlord asserting that he was a family-oriented man who had been rehabilitated. He also cited to Appellate Division case law treating strong family support as a mitigating factor. Defendant maintained that a departure to Risk Level 1 would provide adequate supervision and community notification without overestimating his likelihood of reoffense. The people opposed defendant's departure request, arguing that the factors he relied on as mitigators were adequately accounted for by the guidelines. Supreme Court adjudicated defendant a Level 3 sex offender, denying his request for a downward departure without further explanation. The appellate division affirmed, noting that Supreme Court failed to set forth its findings of fact and conclusions of law, but deeming the record sufficient to allow it to reach its own conclusions. The court held, as relevant here, that his gainful employment and support of his family and friends were adequately taken into account by the guidelines, and, additionally, that defendant failed to establish how his support system would reduce his likelihood of reoffending or his danger to the community. This court granted defendant's motion for leave to appeal, and we now affirm. Under our established three-step framework for adjudicating downward departure requests, the court must first decide whether the mitigating circumstances alleged by a party seeking a departure are, as a matter of law, of a kind or to a degree not adequately taken into account by the guidelines. People v. Ghilotti, see Guidelines at 4. At Step 2, the court must decide whether the defendant has established by a preponderance of the evidence that the alleged mitigating circumstances actually exist in the case at hand. If the first two steps are satisfied, the court must then weigh the aggravating and mitigating factors present in the case to determine whether, under the totality of the circumstances, a downward departure is warranted to avoid an overassessment of the defendant's dangerousness and risk of reoffending. In People v. Anthony, we left open the question of when evidence relevant to the assessment of points for a particular risk factor, including an assessment of 0 points, may also be appropriately considered as mitigation in the context of a request for a downward departure. We now answer that question in the affirmative. Although the guidelines set forth that a court may depart from an offender's presumptive risk level if special circumstances warrant, the expectation is that the RAI will result in the proper classification in most cases, so that departures will be the exception, not the rule. Guidelines at 4. This concept flows from the premise that the RAI is intended to be an objective assessment instrument, while also acknowledging that an objective instrument, no matter how well designed, will not fully capture the nuances of every case. As a result, if the objective instrument is functioning as intended, in the vast majority of cases, an assessment of 0 points under a particular risk factor will adequately account for that factor's impact on the offender's risk level. However, both Ghilotti and the guidelines contemplate a difference in degree as a proper basis for a departure, and therefore expressly permit consideration of a circumstance that is already covered by the guidelines as either an aggravating or a mitigating factor. Indeed, inherent in the concept that a departure can be based on a difference in degree is the prospect that the assessment or non-assessment of points under a particular risk factor may not adequately reflect an offender's risk of sexual reoffense and dangerousness. Consequently, the non-assessment of points should not preclude a defendant from asserting that same subject matter as grounds for departure as a matter of law, where the RAI does not adequately account for the reduction in risk under the circumstances presented. This conclusion is in keeping with both the community protective purpose at the heart of the Sex Offender Registration Act and the court's obligation to make an individualized assessment of an offender's risk. See People v. Perez, Guidelines at 2. With respect to the mitigating circumstances at issue on this appeal, Risk Factor 15 contemplates the assessment of points for an inappropriate living or employment situation. The commentary observes that release to an environment that provides ready access to potential victims or makes it more difficult for an offender to be detected may increase the likelihood of reoffending. See Guidelines at 17. The potentially risk-reducing effects of an opposite living or employment situation, with steady employment in an appropriate setting or housing with or in close proximity to supportive family or friends, can be asserted as mitigating circumstances despite the assessment of 0 points for an inappropriate living or employment situation, so long as the offender can establish that those circumstances are present to a degree not adequately accounted for by the guidelines. People v. Townsend decided today a typical criminal history to a degree not adequately accounted for by the guidelines may be an aggravating factor. That being said, the portion of the RAI addressing an offender's release environment is weighted less heavily than the rest of the instrument. See Guidelines at 6. At least in part because it attempts to account for variable factors whose mitigated effect can dissipate or cease entirely over time. Moreover, while an offender can petition the court to modify their risk level annually, absent certain statutorily authorized circumstances, the people have no similar opportunity when conditions change. See Correction Law Section 168-0. Such considerations, however, do not justify precluding an offender from establishing strong family support or appropriate employment as mitigating circumstances at the time of their initial assessment, if they can be proven. Throughout, however, the court retains the discretion to take the mutable nature of these factors into consideration when determining the weight they should be accorded, particularly when deciding whether a departure is warranted under the totality of the circumstances at Gilotti's third step. The appellate division did not err or abuse its discretion in denying defendant's request for a downward departure. Significantly, the court did not expressly reject defendant's proposed mitigating factors as a matter of law, but went on to conclude that he failed to meet his burden of establishing that the proposed mitigating factors existed in this case. That is, we understand the court to have concluded that defendant failed to meet his burden at Step 2 of Gilotti in holding that his gainful employment and support of his family and friends were adequately accounted for by the guidelines, and that defendant failed to demonstrate how his support system would reduce his risk of reoffense. This discretionary determination should not be disturbed as it has ample support in the record. Accordingly, the order of the appellate division should be affirmed without costs. Order affirmed without costs. Opinion by Judge Canataro. Chief Judge Wilson and Judges Rivera and Halligan concur. Judge Garcia concurs in result in an opinion, in which Judges Singas and Troutman concur. Decided May 28, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.